LLP means what? A limited liability partnership. It is different from the partnership form. Partnership form is governed by Partnership Act 1932. LLP is governed by LLP Act 2008. Okay, there is a much difference between the both. Hence, partnership rules do not apply to LLP. Neither LLP rules apply to the partnership. Please remember that. Whenever you see any person talking, saying LLP as a partnership, please correct that person. It is not a partnership, it is a LLP. Please. Okay, it's a new concept. Hence people take time. Okay, so we have to start with that. LLP is an incorporated partnership formed and registered with LLP Act 2008 with limited liability and perpetual succession. LLP is viewed as an alternative corporate business vehicle that provides the benefits of LLP but allows its partners the flexibility of organizing their internal structure as partnership based on mutually arrived agreement. LLP is different from the company. LLP is different from the partnership also. We'll see that. Okay, there is a much difference between the both. Hence, partnership rules do not apply to LLP. Neither LLP rules apply to the partnership. Please remember that. Whenever you see any person talking, saying LLP as a partnership, please correct that person. It is not a partnership, it is a LLP. Please. Okay, it's a new concept. Hence people take time. Okay, so we have to start with that. LLP is an incorporated partnership formed and registered with LLP Act 2008 with limited liability and perpetual succession. LLP is viewed as an alternative corporate business vehicle that provides the benefits of LLP but allows its partners the flexibility of organizing their internal structure as partnership based on mutually arrived agreement. LLP is different from the company. LLP is different from the partnership also. We'll see that. These are the salient features of LLP. From salient features, you can derive the distinction between the LLP and company and LLP and partnership. LLP is a body corporate and a legal entity separate from its partners. Any two or more persons associated for carrying on lawful business with a view to profit may, by subscribing their names to incorporation document and filing the same with ROC, form LLP. The LLP has a perpetual succession. Very clear with this. For your information, if LLP has to be incorporated, it has to be incorporated with MCA only, that is Ministry of Corporate Affairs. Understood? Likewise, we incorporate company on the same portal. We incorporate LLP also. Please remember that. Okay, but laws are different. Companies are governed by Companies Act and LLPs are governed by LLP Act. But the portal is the same. That is, filing portal is the same. Mutual rights and duties of partners of LLP inter se and those of LLP and its partners shall be governed by agreement between them or between LLP and partners subject to provision of proposed legislation. LLP is separate legal entity liable to full extent of its assets, and liability of members or partners being limited to their agreed contribution in LLP, which may be tangible or intangible in nature or both tangible and intangible in nature. Every LLP shall have at least two partners and shall also have two individuals as designated partners, of whom at least one shall be resident in India. LLP shall maintain annual accounts reflecting true and fair view of state of affairs. Statement of accounts and statement of solvency has to be filed every year with the ROC. Designated partners means the working partners in short. Understood? Accounts of LLP shall also be audited subject to any class of LLPs. CG has power to investigate the affairs of the LLP if required by appointment of competent inspector. Indian Partnership Act shall not be applicable to LLPs. A partnership firm, a private company, an unlisted public company may convert themselves into LLP. Very clear with this? Understood? CG has made rules for carrying out provisions of the LLP Act. Now we'll see the distinction between LLP and partnership. This may be asked for 4 marks or 5 marks. LLP is separate legal entity, whereas partnership is not distinct from its members. Partners of LLP have limited liability, whereas partners in the partnership firm do not have limited liability. Retirement or death of partner does not dissolve LLP because it is having perpetual succession, whereas death or retirement of partner would dissolve the firm. In partnership, property of firm is property of individuals, but in LLP, property of LLP is not that of the individuals. Yes, LLP can buy shares of the company. Yes. Whereas partnership can be formed either orally or by deed of agreement. LLP has to be incorporated with MCA properly. Whereas registered or unregistered partnership cannot have more than 20 members. LLP can have more than that number since there is no upper limit prescribed. Lower limit is 2, there is no upper limit in it. Okay, please remember. Now, distinction between LLP and a company. In case LLP, the need for classifying the object clause into main and all these things are not there. We have to just file incorporation form number 2. In that we have to provide with certain particulars. That's it. It is not a huge process like incorporation of a company. Very clear with this? In case of LLP, limited liability partnership agreement is prepared, whereas in company, articles and memorandum are prepared. Whereas memorandum of company is required to name the state in which it is incorporated, there is no obligation in LLP. In LLP Act, there is no such stipulation for meeting of partners, but in Companies Act, we do have that stipulation. There is no separation of management and ownership in the LLP, but yes, there is separation of management and ownership in the company. In case of company, no individual director can conduct the business, but in LLP, yes, an individual director can conduct the business. Very clear with this? Understood? Now, incorporation of LLP. Okay, this all are the this is all book and everything is given in your book. Actually, I'll tell you actually how it is incorporated. Okay, same like the company, we have to first find out, like means there should be at least 2 partners in LLP, so 2 people are required, out of which one should be the designated partner. I'm sorry, one should be the resident of India. Very clear with this? So 2 foreigners cannot form an LLP. After that, we have to take DIN of those partners. If they already have DIN, then it can be used as DPIN also. DIN is Direct Identification Number and DPIN is Designated Partner Identification Number. But it is said by the MCA, clarified by the MCA, that when a person is having DIN, the same number can be used as a DPIN also. Very clear with this? Then, when both are having DIN, then we have to file first form, that is form 1, for the reservation of name of LLP. Very clear with this? Understood? So, after filing form 1, ROC shall confirm the name within 15 or 20 days. After confirmation of name, that name is available for 60 days from the date of the confirmation. So within 60 days, we have to form the LLP. If we don't form LLP, the name lapses. Very clear with this? After that, we have to make the incorporation documents. Incorporation documents may few documents are there, like consent of partners, then you have the subscription clause, etc., etc. Those all are to be attached in form number 2, which is the incorporation form for LLP. That is to be filed with the ROC and pay the required fees. Once all the documents are proper, ROC shall confirm the incorporation of the LLP and the certificate of incorporation shall be given. It is a conclusive proof. Very clear with this? Understood? After incorporation of LLP, now within 30 days of incorporation, we have to file the LLP agreement. Very clear with this? So LLP agreement is not filed at the time of incorporation, but it is filed after the LLP has been incorporated. Very clear with this? Understood? Any doubt still here? And for filing LLP agreement, it is form number 3. Please remember this. Okay, and LLP agreement is to be prepared on the stamp paper along with the notary done. And stamp paper value depends on the capital contribution of the partners. And registered office is to be the address of the registered office has to be given along with the form 2 only. There is no stipulation like company, like we can file after 15 days of incorporation. No, there is nothing like that. Initially only you have to file the registered office address. There is no MOA, AOA, hence there is a LLP agreement, and that all the duties, rights of the partners. LLP agreement is same like your partnership agreements. Partners and designated partners. Every LLP shall have 2 designated partners, 1 individual. At least one of them shall be resident in India. It provides that any individual or body corporate may be partner in LLP. But designated partner shall always be an individual, please remember. An individual shall not be capable of becoming partner of LLP if he has been found to be of unsound mind by court, he is undischarged insolvent, he has applied to be adjudicated as insolvent and his application is pending. Every designated partner of LLP shall obtain DPIN. Very clear with this? Disqualification. If he has at any time within preceding 5 years been adjudged insolvent, suspends or at any time within preceding 5 years suspended payment to his creditors and has not at any time within preceding 5 years made a composition with them, has been convicted by court for any reason, any offence involving moral turpitude and sentenced in respect thereto imprisonment for not less than section 30 of the. Now we'll go to disadvantages and advantages of LLP. Go to first advantages. It's a separate legal entity. It has perpetual succession. The liability is limited and there is internal flexibility. Disadvantages is lack of privacy because there has to be disclosure with ROC every year. Requirement of LLP agreement, it is necessity. No one can avoid this. Then is a legal uncertainty because it's a newly introduced concept or it is very hit concept. We the professionals can form LLP. You all are aware of that. Instead of partnership firm, we can form an LLP. Okay. LLPs are eminently suited to professionals like company secretaries. They will get benefit of LLP and insulate them from third-party claims against professional negligence or the deficiency. A cross-section of professionals may come together under banner of LLP. Cross-sections means chartered accountants and company secretaries can come together to carry on professional work in their respective field of specialization, respective statutes according sanction for such dispensation. Such arrangement will bring professionals closer. This will benefit the corporates and other clients also because nowadays clients want everything under one roof. This will also create a strong organization of professionals and act as a bulwark against keen competition expected to happen from the professionals There is no upper limit to it. But all members shall be professional. That is a prerequisite. There is no maximum limit prescribed. Now audit of LLP. LLP whose turnover does not exceed 40 lakhs and contribution does not exceed 25 lakhs need not get its account audited. That does not mean they don't have to keep accounts, but the directors can keep the accounts. Okay? Where partners of LLP do not decide for the audit of the account, so such LLP shall include in statement of solvency and statement of accounts by partners to effect that partners acknowledge their responsibilities for complying with the requirements of the Act, and that is to be filed in form number 8. Audit of LLP may be done by chartered accountant in practice only, same like our companies. Annual return of LLP having turnover up to 5 crores during corresponding financial year or contribution up to 50 lakhs shall be accompanied with certificate from designated partner. But where turnover crosses 5 crores, the contribution cost crosses 50 lakhs. Over there, a compulsory certificate from company secretary in practice is required. Understood? Same like the private company and OPC. Now foreign LLP. When a foreign LLP establishes a place of business in India, within 30 days of that, they have to file form number 27 with ROC. In that form, they have to attach copy of COI, that is where it has been incorporated, full address of registered office or principal office of LLP in country of its incorporation, full address of office of LLP in India, which is deemed to be the principal place of business in India, and list of partners and designated partners, if any, name and address of 2 or more persons resident in India, authorized to accept on behalf of LLP service of process and any notices or other documents required to be served on the LLP. Now, winding up of the LLP. LLP can be wound up voluntarily or by tribunal. Voluntarily means partner don't want to continue, they want to wind up. Like partnership firm, they cannot just close the shutter and go away. No, it's incorporated by law and it will be dissolved by law only. Understood? So, one easy way of dissolving the LLP's FTE, that is fast track exit. Understood? Same like the company. The another way is winding up office. Now, why will tribunal order the winding up of the LLP? We have to see the reasons. Over here, there is no procedure is not given. Okay, so you need not read the procedure of winding up. If LLP decides that LLP be wound up by the tribunal, if a period of more than 6 months, number of person of LLP is reduced below 2. If LLP is unable to pay off its debt, if LLP has acted against the interest of sovereignty and integrity of India, security of state or public order, if LLP has made default in filing with ROC, the statement of account and solvency or annual return for any 5 consecutive financial years. Or if tribunal is of opinion that it is just and equitable that LLP to be wound up.